If you've ever waited years for your green card, if you've stayed up late filling out paperwork, if you've sacrificed sleep, comfort, family time, or even career opportunities just to build a life in the United States, then what I'm about to tell you matters deeply. Imagine one day opening your mail, checking your phone, or stepping into an immigration office only to hear that your green card was canceled, that you will no longer be interviewed, that Congress has rewritten the rules and your future is suddenly uncertain. That kind of news doesn't just change forms. It shakes people's lives, their plans, their children's futures, and the very idea of home. If you're watching this today from within the United States or from another country dreaming of living here, take a deep breath and stay with me. Because we're going to break down what our Congress 2026 is proposing, what green card cancellations really mean, and what you can do to stay safe and informed. Before we get into the details, I want to talk to you like a neighbor, not like a lawyer reading legal text. This is about what Americans and immigrants really experience every day. When people talk about immigration updates, it can sound confusing, distant, or even scary. But what we're discussing today affects real lives in very real ways. Parents, students, workers, entrepreneurs, spouses, children, all of you with green cards or those waiting for them, deserve clear, calm, truthful guidance. That's exactly what we are going to do. Let's start with this question. When people say green card cancellations, what do they actually mean? A green card, formerly known as lawful permanent residency, is a legal status that allows someone to live and work permanently in the United States. It is not citizenship. That means certain rights and protections apply, and certain responsibilities must be followed. Under U.S. law, a green card can be lost or canceled if the holder fails to maintain residency, commits certain serious crimes, or obtained the green card through fraud. So, when you hear rumors or headlines saying green cards being canceled, it's often referring to those legal scenarios where residency requirements or legal compliance issues are at stake. Now let's add Congress in 2026 into the conversation. Congress does not have the authority to spontaneously strip thousands of green cards without legal process. That would contradict fundamental rights and due process protections. What Congress can do, and what is being discussed for 2026, are proposals to change how immigration enforcement works, whether interviews are required, when interviews can be skipped, how residency is verified, and how long certain processes might take. These proposals can affect green card processing and renewals, but they do not mean that green cards will be arbitrarily canceled by waving a wand. So, what is the real context for these updates? In the years leading up to 2026, the U.S. has seen several waves of immigration policy debates. Some lawmakers want to tighten enforcement, others want to make pathways to permanent residency smoother, and many want a balance between border security and humane immigration systems. In this environment, proposals often arise that sound shocking on the surface, but are actually complex legal reforms with many safeguards. The important thing is to separate clickbait language from actual legal risk. One of the proposals being circulated in 2026 congressional discussions is related to eliminating some routine green card interviews for certain categories of applicants. Traditionally, when someone applies for a green card, they often have to go through an in-person interview with a U.S. immigration officer. This interview serves to confirm identity, intentions, and eligibility. It's a standard part of the process, and for many, it's nerve-wracking but normal. The idea discussed in Congress is to streamline cases that are routine and low risk so that interview capacity can be focused where there might be greater questions or complexity. In other words, some applicants might no longer be required to attend an interview if their paperwork and background checks are clear. This is intended to reduce backlogs and speed up green card approvals, not to strip anyone of their status. But here's where confusion arises. When people hear interviews eliminated, they think that applicants will suddenly be denied or their status taken away without a chance to be heard. That's not how the law works. Eliminating interviews for some cases means the applicant's file would be carefully reviewed on its own merits, and if anything raises a question, the agency can still request an interview or additional information. This proposal does not mean automatic cancellation. It means efficiency. For example, someone filing for a green card through marriage or through employment with a long history of compliance might, under proposed rules, have their case approved solely through file review if there are no red flags. Now let's talk about the most important concern, the fear of cancellations. People worry that Congress could just pass a law and that millions of green cards would be canceled overnight. That's not legally possible without due process. The Constitution protects lawful permanent residents against arbitrary government action. If green card status is ever questioned, the government must follow legal procedures. Notice, evidence, opportunity to respond, and in many cases, an immigration hearing. You do not suddenly lose your status without a legal process. That said, there are genuine situations where green card status can be lost. Long absences from the United States without proper documentation, committing aggravated crimes, or committing fraud to obtain the card in the first place. These risks are tied to the law, not random congressional whim. Think of it like this. You work hard, you study the rules, you file paperwork honestly, and you follow the law. In that case, the chance of losing your green card because of new legislation is extremely low. But if you misunderstand the requirements, like how long you can be outside the United States or what conditions might jeopardize your residency, that is where the real risks come from. And that's what we will make sure you understand today. Let's take a step back and talk about why Congress even discusses immigration reforms in the first place. Immigration law in the U.S. is defined by statutes passed by Congress. The Immigration and Nationality Act is the foundation. Over time, different presidents and administrations shape enforcement through regulations and policies, but the base law comes from Congress. Every few years, lawmakers debate adjusting those laws to reflect economic needs, humanitarian concerns, border security, and labor demands. In 2026, these discussions are happening again because immigration continues to be an important issue for employers, families, and the national workforce. Some members of Congress argue that the green card system is too slow, too backlogged, and too expensive. They propose ways to reduce wait times, adjust eligibility categories, and make the process more predictable. Others argue that enforcement should be stronger, that residency requirements should be more strictly verified, and that there should be fewer opportunities for fraud or misuse. Both sides can influence future immigration policy, but influence does not mean sudden cancellation of green cards. Let's talk about a real example to make this clearer. Imagine a woman named Sophia, who has lived in the United States for 5 years as a lawful permanent resident. She moved here from another country to join her spouse. She filed all her taxes, maintained her home, and followed every rule. Under new proposals, her next green card renewal might be processed faster, or she might not have to attend an interview at all. That change wouldn't jeopardize her status. It would simply make the process smoother. Now imagine another person who obtained their green card years ago through fraud, misrepresentation, or deception. In that case, regardless of congressional action, U.S. immigration authorities can investigate, initiate removal proceedings, and potentially cancel the green card because the underlying legal basis for their permanent residence was invalid from the start. That has nothing to do with political party or presidential administration. That has to do with the law. Some viewers might be wondering, does the term "no further interviews" mean that green card holders are being denied the chance to defend themselves? That's an understandable fear, but it's not accurate. If an interview is unnecessary because the file is complete and credible, that often benefits the applicant. Faster decisions, fewer delays. But if there is something in the file that needs explanation, the government will still request an interview or additional evidence. The idea of eliminating interviews is about efficiency, not denial of rights. Now, I want to talk about another common myth. The idea that Congress can target a specific group, for example, people from certain countries or with certain visa categories, and cancel their green cards en masse. Immigration law does not allow Congress to pass laws that retroactively take away a person's lawful permanent resident status without due process. That would violate principles of fairness and legal protections under the Constitution. For any removal of status, the individual must be given notice, the government must present evidence, and the person must have an opportunity to respond, often with legal representation. This is not casual or secret. It's a legal procedure with safeguards. But with proposed changes in 2026, there could be adjustments to how green card renewals are managed. For example, lawmakers might propose longer validity periods for green cards, changing interview requirements, or adjusting the documentation required at different stages. In some discussions, lawmakers have expressed interest in automating certain eligibility checks, reducing paperwork redundancies, and increasing the use of technology to track compliance. These measures are generally aimed at solving backlogs that have frustrated applicants and attorneys for years. Another question I hear from many of you is, does this affect my ability to become a U.S. citizen? Excellent question. Permanent residents often plan to naturalize after meeting certain requirements. Changes in interview policy could affect citizenship applications in terms of timing or process, but again, they cannot take away your eligibility without cause if you meet the legal criteria. To become a U.S. citizen, you must meet residency requirements, demonstrate good moral character, pass English and civics tests, and be willing to swear an oath. Proposed changes in processing do not erase these requirements. They may simply change how or when interviews are scheduled. Let's talk about the real emotional side of this. Many immigrants watch news headlines that say shocking things like green cards canceled or no more interviews without context. That can create anxiety, fear, and the feeling that everything you've worked for could be taken away. That fear can be emotionally overwhelming. I want you to know I understand that. Immigration status is not just paperwork. It represents hope, family unity, opportunity, and security. When there's uncertainty in law or politics, it's natural to feel worried. But fear, without understanding, leads to confusion and bad decisions. This is why trusted, step-by-step information matters so much. You deserve the facts, not rumors. So let's walk through what you should do next if you're worried about these proposed Congress 2026 changes. First, stay informed from reliable legal sources. That means official government announcements and qualified immigration attorneys and channels that explain without exaggeration. Headlines are written for clicks. Legal updates are written for clarity. Second, understand your own case. Immigration law treats different people differently. What applies to someone applying for a green card through marriage may differ from someone seeking asylum or employment-based residency. Third, keep your paperwork organized. Your green card, passport stamps, tax returns, employment letters, and other documentation can help show your compliance with U.S. law and make any interactions with immigration officials smoother. Here's another example. Let's say Amina has a conditional green card through marriage. Conditional residents often have a separate interview requirement to remove the conditions after 2 years. In proposed changes, if interviews are reduced, Amina might be eligible to simply submit stronger documentation rather than attending an in-person interview, which could reduce stress and waiting time. But if there's missing information, the government can still request an interview or clarification. Your rights remain. Another real situation is someone like Luis, who has had a green card for many years and now faces renewal. Under older systems, he might have waited many months for an interview. Proposed changes could mean faster renewal processing and fewer delays. That's a positive outcome. But if there's confusion or incomplete paperwork, the process could still require an interview. And sometimes that's necessary to protect both the applicant and the government from mistakes. Now, something crucial. Proposed changes by Congress do not mean mass audits or blanket investigations of every green card holder. That's political fear-mongering when you see it in headlines. Practical legislative proposals focus on system efficiency, modernization, backlog reduction, and targeted enforcement where the law already allows it, such as fraud cases or individuals who have genuinely abandoned residency. So, let's answer the big question plainly. How risky is this for green card holders? The answer depends on your personal compliance with the law, your understanding of your responsibilities as a permanent resident, and your preparedness for changes in process. If you're in good standing, you meet residency requirements, pay taxes, follow the law, and keep your documentation updated, your risk of losing your green card because of congressional updates is very low. But if you are not meeting residency requirements, for example, you spend long periods outside the U.S. without a re-entry permit, then your risk of encountering problems is tied to that, not to Congress changing interview requirements. Losing a green card because you failed to meet the law's residency conditions is not the same as losing it because of a political decision. The law has always required that green card holders maintain residence in the U.S., and that has not changed. We'll continue with part 2, where I explain how to interpret the proposed legislative language, what to do if your case is affected, and real-world examples of immigrants navigating similar updates successfully. Please tell me, continue with part 2 when you're ready, and I'll generate the next section of the script.